Maybe turn down the AC down. Is it? Okay. Okay, so the topic I was gonna talk about is the question or the sort of difference between having a constitutional tribunal and having a Supreme Court, right? So we know the US, but also India, they have a Supreme Court that does judicial review, meaning that if a law contradicts the Constitution, the Supreme Court, and maybe also other courts, we'll come to that in a second, can say this law is unconstitutional, right? Many other countries have this different model, which is to have a constitutional court or a constitutional tribunal. And what is distinctive about the constitutional tribunal is two things, or, well, a number of things, but at least two things. One is it's a specialized court, so it only does constitutional cases, right? And it comprises usually of 9 judges, most countries, and they're usually not appointed for life. The question is how long should they serve, but it's usually not life. So the idea of a constitutional court is usually attributed to Hans Kelsen. He's a very famous legal theorist from Austria. And he had this idea that, you know, a constitutional court is kind of a political body. It's not a legislator, but it's very political in nature. He called it a negative legislature. They do the opposite of making law, they destroy law, right? So it's a negative legislature. And as a result, it needs to be a little bit political in nature. So he said they should be appointed for probably like 9 years or so. His idea is it should be longer than parliamentarians. It shouldn't be exactly that a new parliament gets to appoint new judges, because then they're only political, right? So it should be a little longer than that, but it shouldn't be for life. That was Hans Kelsen's idea. So it's sort of a balancing between judicial and political, because he said they're different from other judges, because they're a negative legislature. They get to destroy law, right? That's Hans Kelsen's idea. So that's one thing that's different. The second thing that's different is that it is a court that it's a different type of constitutional review in many cases, in that it also happens before a law is passed. So in countries with a Supreme Court, usually you can only bring a case to the Supreme Court if you have what they call a case or controversy, meaning your rights are actually being violated and the law has already become law, right? Or there is an actual violation of a law that has already become law. Then you can bring a case. Whereas in a constitutional court, you can bring a case before a law is passed into law. And you can say, hey, this law that you're planning on passing is going to be, we think it's unconstitutional, and we're bringing it to the court so that it will never become law in the first place, right? It's a negative legislature. It's almost like an extra step in the lawmaking process. Before it becomes law, you ask the court, is this law constitutional? We call this abstract review without a specific case. Whereas the Supreme Court only does concrete review, right? When there is a case and the law is already law. So it's a specialized body, and it also does concrete judicial review. Those are important features of it. A lot of people like constitutional courts for new democracies, and let me tell you why, and then maybe we can also talk about whether that's right. But there is a certain sense. So one country that adopted a constitutional court is South Africa. Why did they adopt a constitutional court and not a Supreme Court? And South Africa, like Myanmar, comes from a common law tradition, or it's a former British colony. In any case, it's a bit more complicated. They also had Roman, Dutch influences, but I won't get there. So why did they do that? Because the constitution makers at this time were thinking, well, all these judges, they were appointed by the apartheid regime, right? The nationalist party that left power. All these judges were appointed for life, right? So are you going to fire all the judges? That's difficult to do, right? So there's a certain sense, this entire judiciary is still stacked with judges from apartheid South Africa. They were often good jurists, but they were appointed by a government that we don't necessarily trust anymore. So it's easier to start over again with a new constitutional tribunal. And the advantage is, all we need is 9, right? We just need to find 2 good men or women that know constitutional law and have, in many cases, they actually appointed judges that have some expertise in international human rights law too. Because if you're a new country, you have to start building up a constitutional jurisprudence, deciding constitutional cases. You don't really have your own case law to turn to, so you may want to look at international law and international precedent. You may look at how other countries have done so. If you read the first few cases of the Constitutional Court of South Africa, they cite other countries' constitutions. It's like a comparative law textbook. They read, oh, this is how Germany did it, this is what Canada did, this is what Zambia did, this is what Namibia did, and look at this is what we're doing, right? But you only need, the point is you only need 9 qualified people to be on the court, and you don't have to reform your entire judiciary. So as a result, it's often said it's a good thing for new democracies to maybe have a constitutional court. The downside of that is, and we'll talk about the other system a little bit more in a second, the downside of having a constitutional court is that it's only one court, so it's also easier for a government to try to intimidate, right? So we've seen here in 2012 that the Constitutional Tribunal had to resign because it made an unpopular decision. That has happened recently in Poland, for example, where the government basically really didn't like the court anymore because it told the government, you cannot do this, this is unconstitutional, this is unconstitutional. And then the government is like, we're going to change the way judges are appointed. We're going to change the Constitutional Court Act and change how they're appointed. And then the court is like, haha, that's unconstitutional, you cannot do that. And then the government is like, but we're not going to publish your decisions anymore. Sorry guys, we just don't publish your decisions anymore. And they stopped publishing it. And then, and this went on for a long time because then the court started publishing its own decisions, and then there was another amendment to the Constitutional Court Act, and the court said again, no, that's unconstitutional. But the end of the story is that the court is no longer really independent, right? So there is so on the one hand, it's easier to create these bodies, but of course they're also a little bit more vulnerable than a Supreme Court model. So I'm gonna ask Kevin to maybe explain the US Supreme Court model and how this works in the United States, because it's one model where the Supreme Court does judicial review. One of the things I found when I was researching Myanmar was that apparently in 2014 there was a proposal from the NLD to bring the power of constitutional review to the Supreme Court. I don't know much about it, I just know that there was a proposal. And one of the arguments that was made was that this is a common law system, and common law systems usually have Supreme Courts. That is true. The only exceptions are South Africa, which is a common law system, Sri Lanka, which is a common law system, and Zimbabwe in 2013 established a constitutional tribunal. But most of the common law systems, they have a Supreme Court. I mean, as a lawyer, I do have to say though, in some ways, Myanmar feels more like a civil law system to me, because everything is done through legislation, right? If you're a common law system, all the judicial decisions are the law, right? But I don't think if you go to law school here that you read a lot of cases. That's what I heard when I talked to people. I don't know, I need to know more about this. But in any case, it clearly comes from the common law tradition, historically. So, and it is true that most common law systems have a Supreme Court that does cases. So I think I'm going to turn it to Kevin to sort of explain how this works in the US as one example of how a Supreme Court can decide cases. And as you'll learn, it's not just the Supreme Court.
Right, as she said, so in the US, the Supreme Court has the power to hear constitutional cases, but it hears a very small percentage of all constitutional cases. I don't know for exactly, but if I had to guess, I'd say maybe 1% to 2% of all cases. So the reason for that is that there are thousands of courts all across the country, and they're divided into 2 levels of systems. Because the United States is a federal system, we have one set of courts for the federal government, for the US government. There are federal courts. And then at all of the 50 states, each of the 50 states has their own separate system of courts that they create themselves. It's entirely or mostly up to each state how it wants to organize its courts. And each of the 50 states has its own Supreme Court. So it's complicated. You can spend a whole year in law school taking a course that just studies the relationship between the federal courts and the state courts, called federal jurisdiction. So, but I'll try to summarize it in about 2 minutes and see how we do. So the state courts are essentially the final say. They have supreme say over issues of state law. And in the United States, most of the day-to-day issues, legal issues you come across are state law, not federal law. So almost all of criminal statutes, the criminal statutes, the law governing contracts, the law governing torts, or when some person injures another, that's governed by state law. Most things are state law, and so if you have an issue, you would typically be in a state court. So I'm from the state of Ohio, I lived in the state of Virginia, I lived in the state of California, Mila's lived in the state of New York. If we had an issue, we'd take it to the California court that's just in town, down the street, and then that issue would be resolved by that court, and if it were appealed, it'd be appealed to an appellate court, and then perhaps to the Supreme Court of California or the Supreme Court of New York. The federal courts, the United States courts, would have no role in it whatsoever. So that's the lion's share. That's the massive, overwhelming percentage of cases that are heard in the United States. And because each state has its own constitution itself, if you have a state constitutional issue, then that state court will resolve it for you. So those are the states. So, but occasionally, there are issues that are heard by federal courts. And so what are those types of issues? First of all, cases involving federal law. So anything involving everything from the US federal constitution to US statutes to US regulations, which are created by administrative bodies. Those are all part of federal law, and those would be resolved by federal courts generally. There's also an option to use a federal court if you're litigating across state lines, so you have a neutral court and not one state's court or the other state's court. That's also complicated. But the takeaway is that the federal courts are deciding federal law. And every court in the country, and there are roughly 100 district courts in the United States, scattered all throughout the country. These are trial courts called district courts. They have the power to determine constitutional issues. So if you want to challenge a statute of the United States or a regulation because you think that it's violating your constitutional rights, you file that suit in the federal district court typically, and the court then will hear the case and months or years later issue a decision. And it has the power to stop the federal government from violating the Constitution if it decides that it's doing so. So that's all 100 courts, and each of the courts have roughly 10 to 12 judges. So we're talking, counting all the other courts, about 2,000 district court judges are all around the country. Each single one, with a single order, can stop the federal government from violating the Constitution. And the federal government is bound to obey it. Now, if you go to district court and you have a decision, whether you're the government or a private party or a corporation, and you're dissatisfied, you can appeal to the next level, which is called the circuit courts or appellate courts. There are 13 of those divided into regions across the country, and they have to hear your appeal. And so many people who lose in the district court then will take it to this appellate court, and that's typically a panel of 3 judges who together hear the case. And then when you filed your briefs, and then they often will have oral argument in front of the court. So your lawyers and the parties will go to that part of the country, do their argument, and then it will issue a decision some months later, and then that's the final word. They may reverse the district court, or they may uphold the district court. And so these 13 appellate courts are where the vast majority of constitutional decisions are made. The vast majority of all issues, including constitutional issues, the final say is by the U.S. Courts of Appeal all throughout the country. And there are about 200 active judges on those courts altogether. So on top of all this is the Supreme Court. And I mentioned that last because in many ways it's actually the least significant. So if you lose in the Court of Appeals, you can file a petition, have your court case heard by the Supreme Court. But it turns out the Supreme Court only hears, give or take, about 100 cases per year out of tens of thousands that are heard by the appellate courts. So that means that something like it only accepts only 1 to 2% of all the appeals that are filed with it. And it only accepts those cases that it thinks are most important issues of federal law, either because there's a disagreement between the different courts, or because it's an issue that affects a lot of people, or it's just something that the country would benefit from having uniformity on. So that's a tiny percentage of cases that are heard in the Supreme Court. But then it does, of course, have the power to reverse, to overturn decisions of the Court of Appeals if it disagrees. And it does that a little over half the time that it hears. Yeah. So this is how constitutional issues are adjudicated in the United States. And I think it's unusual for many countries. Mila can add to this, but it's unusual in that it's not just one Supreme Court or one constitutional court that's hearing and deciding constitutions, but every single judge in the entire country can do that. And it's also true that state judges can hear that, but that's more complicated than we have time to get into that. But the point is, that the reason that judges have the power to decide constitutional issues is because the Constitution is the supreme law of the land. It's at the top, followed next by statutes passed by Congress of the United States, and then followed by regulations and state laws. And so whenever a court of any kind is considering an issue, it has to apply all of the relevant law. It can't just choose some law to apply. And the Constitution always applies. So if the statute in question or the regulation in question is in conflict or in tension with the Constitution, the court has no choice but to say, I'm going to apply the law of the United States, and I start with the Constitution. And if the two are conflicting, then the Constitution wins. And so that's how constitutional issues can infect and become part of many different cases at all levels of courts.
And at some level, there's something really great about it, and that it's hard for any given politician to intimidate the Supreme Court all that much, or in any case, there's not that much to be gained, right? There's this famous episode in U.S. constitutional law where President Roosevelt, who was served more terms than any other president, decided that he didn't like the Supreme Court very much because he had a social welfare agenda and the Constitution had strong property protections, and the court kept striking down the laws that were passed. So he was like, I'm gonna do something about this court. And there is 9 judges on the court, but nowhere in the Constitution does it say it has to be 9. So he's like, I'm just going to appoint number 10. Nobody's going to stop me from appointing number 10. And number 10 is obviously going to be a judge that likes me, or that I like, right, and likes me. And then the court was sort of, uh-oh, this is going to happen. So the court kind of switched its tune, and it said, actually, you can pass those laws after all. It often happens, right? Even in a country like the U.S., I mean, courts are not immune from politics. There never are. But there
was a strong political backlash to the court. It's called court packing, right? You pack as many judges as you can into the court. And so obviously, especially from his political opponents, they were quite upset.
Actually, if any of you is ever going to draft a new constitution, which, it's possible that may happen in your lifetime, it's always a good idea to write down explicitly how many judges have to be on the court, because this is often exploited, right? It turns out, and this is true in the US, but also in Poland, right? Not clear how many judges should be on the court. Fine, let's appoint 5 more. right? That way you get a majority. So it's just a small thing. But what was I going to say? So these episodes happen, but President Roosevelt would only control the Supreme Court, and there's still all these other courts doing judicial review, right? So one of the things, for example, I was in Poland, where the government successfully neutralized the Constitutional Tribunal, and now all these judges in Poland on other courts are discussing, maybe we can also do constitutional review, right? Because if the Constitution, as he says, is the highest law of the land, if we are all going to do it, then it's much harder for the government to control us, right? But somehow this has to happen in a system whereby the court's starting to say this is the case.
Incidentally, all federal judges in the United States who are appointed under a certain clause have lifetime tenure. So once they're appointed and go onto the court, whether it's the Supreme Court or a trial court, they cannot be, they serve for the rest of their life as long as they want. Mm-hmm. Their salary can't be reduced. It actually automatically increases most years.
We get paid well.
Yeah. Yeah,
I think Singapore is the country that pays the judges the most for some reason. They're very. Let me make one point, and then I'd love to get. Both love to take questions. So one other country with a Supreme Court that may be interested to think about is India, right? So India is clearly a common law system. The Supreme Court. So in India, I believe it is true that most courts can do constitutional review. However, there is a really important difference with the US in that the Indian Supreme Court has said everybody can go directly to us. You don't first have to go to a lower court and then appeal, and then maybe we'll take your case if we like it, right? Like the US Supreme Court. The Indian Supreme Court decides thousands and thousands of cases a year. The US Supreme Court is quite lazy by comparison, to be honest. Seriously, thousands and thousands of cases, and they go. And people go directly, right? It's sort of it's one of the really important innovations in Indian constitutional law is the court allowing these direct appeals, direct access to the court. And I think in the sort of comparative literature, access matters a lot, right? Being able to access a court, rules of standing, as we call it. So if courts are easy about this, right, and be like, if you send me a letter, or maybe even a newspaper article, where you say that your rights are violated, and we're going to take the case, that's a really big deal, right? That's a really big deal. So a lot of, and this is the same for a constitutional tribunal, right? You can have a constitutional tribunal where only government officials can bring cases, and you can have a constitutional tribunal that allows for individual petitions. Individual petitions meaning individuals can bring cases to the court. A lot of constitutional courts allow for individual petitions. Only some do not, right? And I think your own constitutional tribunal is an example of where people cannot bring cases directly to the court. So it goes to the initial question, what if there is a problem with implementation? Where do I go, right? And as an individual, the answer is nowhere. You first go to your member of parliament who can then, I think the speaker of the different houses can bring a case, the president of the union can bring a case, and the chief justice of the Supreme Court can bring a case. That's very, very limited, right, in terms of who can bring cases. So it's not so surprising that you have very few cases. You can imagine a court where more people can bring cases. Okay, questions, right? Many questions. Okay, you want to start, and then we'll come around.
Yeah. Yes, thank you. Right now, according to your presentation, I'm interested in the word constitutionalizing, especially, the situation of Myanmar. So we are going for the federalism. So in United States, constitutionalization, what I'm understanding is all of the state member of the federation have to give up their sovereignty to the central, some of their power to the central government. So in here, we are all the time trying to argue, self-determination and autonomy. So mostly, trying to have a full power to decide what to do everything within their state. But according to, American system, American Constitution, like the Fourth Amendment, so most of the states have to give it some of their power to central government. So my question is, how does this play, in the federalism, a dream of federalism, what we are struggling in Myanmar. And can you, elaborate more about that kinds of situation? Thanks.
Do you want to talk about the U.S. first, and then I can talk a bit more general?
Real quickly on the U.S. federal constitution, it sounds like you know, and some others may know, that the federal constitution is unusual among federations, among federal systems in the world, in that the states, by virtue, when they ratified the Constitution, they agreed to give the federal government certain powers over certain things. And those things are called the enumerated powers. So they're listed in Article 1 of our Constitution. They involve things like taxation of certain things, raising an army, regulating interstate commerce around the country, and several other things. But it's not a long list. It's a fairly short list. And pretty much everything else is reserved by the states. So the states control, as I said before, have power over criminal law and so forth. So if the US Congress wants to pass a law, they need to find the authority to do it in the US Constitution. And for most things you might want to pass laws about, they don't have that authority. Only the states do. So in most systems, and Neela can talk more about this, it's rather than that way around, it's that the federal government has allowed states some of their power, whereas the states basically gave the federal government some of their power, but reserved most of it for themselves. And those things, that division of power between federal and state is one of the essential parts of federalism, and it's vigorously protected by the courts. That's one of the court's main functions, is to ensure that the federal government doesn't step into areas that only the states can deal with, and conversely, states aren't allowed to deal with things that the federal government deals with. So states aren't allowed to, in general, conduct foreign relations. They're not allowed to do a lot of things related to immigration. Only the federal government can do that. But again, most of the things are controlled by the states.
Great. So let me say one, because federalism, we know it's a really big topic here. I wasn't sure how much to talk about it because I know you've been talking about it a lot with a lot of different people. But on federalism, I think there's a few things that sort of general clarifications that I think are helpful. So first, federalism and decentralization are not the same thing from a lawyer's perspective, right? Decentralization means you're giving away some of your powers, but you can take them back, right? That's the key feature of decentralization. In a federal system, you protect the powers that you're giving away. So it says in the Constitution, the states or the regions shall have those powers. And the fact that you write them in the Constitution means you cannot easily take them back without amending the Constitution. And that is a very fundamental difference, right? So a lot of governments like to talk about decentralization, but not about federalism. And even if they talk about federalism, they really mean decentralization, right? So I think this is an important distinction. Second, federalism and secession are two very different things, right? So sometimes there is this, this is an idea that actually comes from the United States. So at the time of the founding, there was this idea, right? We have this compact. We are independent units, and we're coming together. We're giving away some of our power, but because we have this contract or compact, we have an inherent right to leave and secede. It's part of our right that we keep the right to secede as we join the union. So this was sort of an idea that was floated around a lot in the time of the American founding. And after the Civil War, when a lot of states tried to secede, the Supreme Court says no, that was never the deal. You do not have a right to secede. It is not an inherent part of federalism. And since then, I think, so I actually studied this in constitutions. A lot of federal systems actually prohibit secession, right? There are two separate questions. You can have federalism that says you have a right to secession. There's only one country currently that does that, and that's Ethiopia, right? And Ethiopia, so there is a part of the federal union in Ethiopia means a right to secede. Other countries that used to have it is Yugoslavia, Soviet Union, Czechoslovakia. I mean, what do they all have in common? They no longer exist, right? So a right to secession, I mean, it's something you can think about, but I mean, I think the historical record of countries that have tried it shows that it often leads to disintegration. Actually, one of the constitutions that has a right to secession is the Burmese Constitution of 1947. One of the very few ones in the world, right? So it's which is not to say that that you cannot have such a right in your constitution. You can, right? You can write it in your constitution, but they're two separate design choices. And I think to assume that it's part of federalism, I think is not really substantiated by the record, right? I think most countries that are silent on the question, the court ultimately has to decide, and most courts then decide, no, actually, secession is not an inherent right in federalism, right? So I think it's important to think of those as separate questions. And you can imagine a federal union that has a right to secession, and you can imagine a federal union that bans secession. It's a choice, right? And I think it's a good choice to think about if you're thinking about federalism. Finally, in the literature, there's two types of federalism that people talk about. One is a coming together federalism. It's like the United States, right? You have all these independent states, and then they decide, we're going to give away some of our powers to a federal government, and only those powers and everything else we keep, right? The European Union, we can also maybe think of as moving in that direction. States are giving some of their powers to the European Union. Federalism can also go in the opposite direction, right? You used to be a unitary state, and then you're giving away some of the power to the regions or states. And often this is done in a sort of, not to come together, but to stay together. Because we have ethnic conflict, we have religious conflict, or some sort of divides, and certain groups they want their own education, they want their own cultural rights, and so on. So we think of it as a keeping together federalism. Right, so this is a federalism. Nigeria is an example of a country that went in that direction when it previously wasn't. In Israel, right now, they're talking about this, right? Maybe they should, and it's a tiny country, but still, there's a lot of divides. So maybe you should have a federalism to mitigate some of those divides. But it's an important difference. I mean, Kevin was alluding to this as a starting point, right? Do you start from the negotiating position that you're autonomous and giving away some of your power, or do you start from a negotiating position that you are not and giving away some and receiving some powers, right? And I feel like, having talked to different groups in the country, there's disagreements on what the starting point is, right? And there's, of course, empirical questions. Was there ever a state government that controlled the area or not, right? Was it? But it's an important distinction. So those are some of the hard questions for federalism, I think. And then, I mean, a lot of federalism is about, who gets what powers exactly, right? It's not like just saying we're federal or not. That's not necessarily so useful. You need to think about, how are we going to draw the boundaries of the states? So India, time and again, redrew its boundaries to have a truly ethnic federalism, right? We draw the boundaries along linguistic lines. Other people have said, that's not a great idea. You should really mix up different groups, right? And what you do then is you get just regional autonomy, but within the region, you're going to have different groups, and you're going to have minority rights within the region. You can't just, you can't just only give one group autonomy over a certain region. You need to share power, even at the subnational level. So this is a question, right? How you draw the boundaries. It really affects the kind of federalism you want. What kind of powers are you going to assign to the subnational units? Is it just education? Education is always there, right? It's like the first one that you give to subnational powers. But also how you share natural resources, right? Nigeria is an interesting country to look at, because they made very, very specific arrangements on how much of the resources from the regions can stay in the regions and how much go to the central government, right? So, and all these things are always negotiated in a constitution. So those are, and then finally, a lot about federalism and making federalism work is about contestation and conflict, right? Because we have different groups, they are together, but they don't always like each other very much. So they're gonna have to have conflicts, right? And it goes back to the point, you need a place to resolve those conflicts, and rather than on the battlefield, right? That's the ultimate place to resolve conflict. And for that to be the case, you kind of need a court. It's really hard to think of federalism without a court to mitigate those disputes, right? I can see it work. You know why? Because the federal government will always win. It's stronger, it's more powerful, right? So it's danger. So the danger of the federalism is that it's always state rights become less and less unless states have a way to push back. Right? And if you look at the US, and I'd like to hear actually a bit more about the US today, this is exactly what's happening, right? So for a long time, a lot of the conservative states didn't like President Obama. They tried to, do what they can to stop all these environmental regulations that they didn't want, so they litigated, they said these are our powers, we don't want healthcare, those are our powers, you can't do that as a federal government. Battle after battle after battle. Now, we have President Trump and a lot of the liberal states, they really, really don't like Trump, right? So we've seen California, some people say California sails the sea from the Union, except it cannot, right? Short of civil war, that's not possible. But California is saying, okay, the US stops the Paris Agreement, well, we're gonna try to be part of it, right? The Treaty on Global Warming. The governor of California said, we're gonna launch our own goddamn satellites if the US is not doing it. We are gonna put emission standards on car if the federal government isn't doing it, right? So now these other states are fighting this battle. And in some way, if, in a healthy federal system, everybody thinks it's good to have a place where you can fight those battles. Sometimes you win, sometimes you lose, but at least we get to fight the battle, right? And that's what the courts do. So, and I think it's hard to do federalism without the courts. Do you want to say a little bit more about how the extent to which this gets played out in the US?
Specifically about the recent developments, or
Yeah.
what do you want to hear about?
Well, or we can ask questions.
Let's start with some questions.
There's a lot. Yeah.
Thank you. My question is the problem of appointing the Supreme Court. Because although we think how do we making the Supreme Court to be independent? Even the US, we seen the judge as a conservative judge and a liberal judges. That's why in this far as Obama time, even there's one space is vacant, but they still have to, because of appointed by the president and they acknowledged by the parliament or the Congress, it still don't work. Because in the long term, even the lifelines of the judge and the shape of the judge will be making people worry for their conservatives or their idea, because of that is like a generation to generation gap, and at the same time their capabilities of judging and the reviewing all of the criminals and Supreme Courts. So how do you think about the best Supreme Court systems that will be making the both young and the old generation intersection, and also the making that not to be influenced by the both Congress and Parliament, Congress and the state's government power in this really check and balance and really not influenced by political things.
I think the first thing to keep in mind is that judges, like everyone else, are human beings, and they bring to the bench certain prejudices and worldviews about how policy should be and how the law should be interpreted and what the law should be. And so inevitably there'll be disagreement based on judicial ideology lines, no matter how independent the court is. So even if the court isn't concerned about pleasing the president or pleasing Congress or anyone else, there just is a wide array of judicial, political, and ideological beliefs. And we see that play out